Some of those contract disputes can really be quite acrimonious. Ideally, you hash through them together without getting the court too involved and come up with an agreement that everyone can live with. Sometimes they're pitched battles and they're fall into the category of contested matters. It's rare that that kind of a contract dispute would fall within the realm of what's called an adversary proceeding, which is a full-blown lawsuit. But contested matters can be pretty nasty. And frequently a judge might order the dispute to be resolved through mediation, where you meet with a mediator who tries to bring the parties together to resolve whatever the dispute is. This can be particularly nasty if there's a lot of money at stake, because although I've sometimes had clients say, well, it's the principle of the thing. No, it's never the principle of the thing unless you mean principle as in money. So the dispute then may be resolved either through some sort of mediation, or the dispute may be resolved through litigation in front of the bankruptcy judge. And if either of the litigants is unhappy with the result, that entity can appeal to the next level. In the bankruptcy system in the Ninth Circuit, we have what's called the BAP, the Bankruptcy Appellate Panel for the Ninth Circuit. So if you don't like what happens in the bankruptcy court, you can appeal to the BAP, which is the default. If you don't like that, you can appeal to the U.S. District Court for the district in which you are located. You can't hopscotch back and forth once that's been established. If you don't like that, then you can appeal to the Ninth Circuit Court of Appeals. And if you don't like their result, then you can appeal to the U.S. Supreme Court, but they don't take very many cases in a year, and very few bankruptcy cases. They might take 70 or 80 cases in an entire year from the entire country, and they're not all bankruptcy cases. So usually if there's been an appellate process, it terminates at the Ninth Circuit Court of Appeals. All of this takes time. And so it's usually in the best interest of the parties to try to get this resolved without incurring large legal costs as you keep mounting these appeals. But sometimes there's so much money at stake that the appellate process proceeds apace. Now, there is, with regard to assuming contracts, a certain time frame in which this has to be done. Typically, you assume a contract at any time prior to the confirmation of the plan of reorganization. Now, that can take some time to get the plan confirmed, because this is not like, say, a Chapter 13 case where you file the plan along with your petition, and within a month or two, you get the plan confirmed. Sometimes it can take, well, if there's a lot of litigation, it can take years before the plan is confirmed. I had a case where it was something like 4 years after the petition date and before the plan was finally confirmed because of protracted litigation. I will say that was a somewhat unusual set of facts there. But in any event, generally the contract disputes are resolved in front of the bankruptcy judge. You can also include provisions in the plan that you try to get the contract dispute resolved through the plan itself. But you want to be very careful in putting provisions in a plan that will not pass muster with creditors, because in a Chapter 11, the creditors get to vote on the plan of reorganization. And if you can't get the creditors on board in a way that can be made precise, then you can't get the plan confirmed. Or if you can get some of them on board, you can get the plan confirmed, but you might end up losing your entire interest in the company because of something called the absolute priority rule. And I believe I discussed that in a prior video, so you can do a search on that to find out what the absolute priority rule is all about.